still an issue that she cannot decide at this point. And so I think the general timelines, yeah, it does take 2 to 3 years to get a death penalty case to trial, if that's what the state is seeking. And they are complicated cases. And so thinking logistically, Fremont County typically has harsh winters. So I would just not want it set in November, December, January, February, March. Those are typically typical seasons for a lot of traveling if there's witnesses coming back and forth.
Judge, I'd like to respond if I may.
Go ahead.
Judge, I noted that Mr. Daybell's been locked up for a year and a half. Ms. Vallow's been locked up for a couple of years. And with all respect to Mr. Archibald, it's not Mr. Daybell's fault that Mr. Archibald has not started any mitigation process. It's not Mr. Daybell's fault that they may not be able to get their expert witnesses lined up. I would assume for the last several months, that's what they've been doing because they haven't had to file anything else. So they've got 10 months from now to have a trial. And I think that that's more than sufficient time given the fact that for a year and a half, there's been at least from my perspective, a battle to try to get all of the discovery. Now, if Mr. Wood decides and Ms. Smith and Ms. Blake decide to dump some more discovery, then that'll be an issue that I'll address with the court. But I'm assuming now that after all of this time, that I have all the information that they intend to use in this case. And given that, I can't fathom how Mr. Daybell should be kept in jail for another 2 years, awaiting his opportunity to offer his explanation of this case. And because Mr. Wood doesn't think that he can get ready in that much time. And frankly, he made a representation when I asked for a continuance and waived speedy trial that he was ready for trial. And he's made that representation to this court. Now, if that was an inaccurate statement that Mr. Wood made, that's fine. But he did make that representation in open court, that he was ready for trial. So now if he's saying 2 years later now, because Ms. Vallow's locked up, and he doesn't know what's going to happen with her, and I suspect that's what the reason is. And that's not a legitimate reason to delay it for Mr. Daybell. He wants his trial, and he wants his opportunity to present his case.
All right, thanks, Mr. Pryor. The scheduling of the case is, of course, a matter of discretion for the court, and I've considered the positions laid out here by all sides. Quite honestly, my hope was to have this case tried in 2022. I'd note that while the case at bar here was started in May of this year, it was initially Mr. Daybell was taken into custody and arrested in related case that stemmed first and went into this case, and that occurred back in June of 2020. So that was almost 18 months ago. So even if we looked at a 3-year setting from when he was initially charged, we still wouldn't be to the fall of 2023. And I understand the burden. Well, I won't say I understand it. I've been a prosecutor before, not on a case like this, but I understand it's a huge undertaking, would require a lot of time and preparation, and I want to afford the state that opportunity. But I also have to weigh that against the interests of a defendant to have a timely trial, waiver of speedy time or not. And so in consideration of all of that, I've also done some checking of my own with calendars, coordinating things with Ada County, where this trial is scheduled to occur. And I've determined then that an appropriate time to be looking for trial will be in January of 2023. So that will still provide 14 months of preparation time from now going forward. There's other motions I understand still need to be litigated that could impact things and need to be scheduled as well. In particular, the motion to sever. But in terms of setting trial, I do want to get it on the docket. There's a lot of planning that goes involved, a lot of scheduling issues, and I don't want to be looking at the prospect of having to move the trial once it's set. So upon all those considerations, then council, I'd ask that you start looking at your calendars right now, and let's see what would be available in terms of a commencement date in the month of January 2023.
And Judge, without permission to speak up, I will make a representation to the court that whenever the court decides to set it in January, February, or March of 23, I will be available for whatever the dates the court decides.
All right. I would propose a starting date of January 9th. So if we started January 9th,
Your Honor, the state's one concern with January is travel back and forth. Mr. Pryor himself has said that our officers can travel back and forth, so that's a position he's taken. That puts us in that could very easily put us in a bind. I think even moving it to late February would be a lot more appropriate.
Judge, I think January is going to be fine. We're basically dealing with highway traffic. And having been dealing with this for the last 18 months, traveling between, and quite frankly, really visiting with Mr. Daybell quite frequently in the last 18 months, it's not as difficult of an accommodation as it seems to be suggested.
Well, I highly disagree with that.
Okay, that's fine.
again, it's a speculative issue. Some winters, the interstates are clear all through January. Sometimes it's a nightmare getting from here to Boise. We don't know and can't predict that. It's one factor to consider, but the court would consider that where the trial would be occurring in Ada County, the climate there is much more mild than it is in Fremont County. That alleviates some of that concern. I still would like to consider that start date of January 9th, because then that's going to put us out to, I think it's March. If we wanted 10 weeks, then that would be March 17th or March 24th for an end date. I believe that had put it through March 17th, if I'm counting up all the weeks correctly. Is there any specific objection besides what's been noted in terms of weather or convenience from that setting March 17th as an end date, January 9th to begin?
It's acceptable to the defense of Mr. Daybell, Judge.
We will be ready, Your Honor.
Okay. Well, I appreciate your input on that, counsel. We'll get a scheduling order to that effect. That scheduling order will contain some deadlines for counsel to pay attention to in terms of discovery cutoff, expert witness disclosures, and other matters that are set in accordance with the Idaho criminal rules. So we'll send out a scheduling order on those dates. And while we're talking about scheduling, I mentioned it a little bit previously, but what potentially has some real impact here is the filed but not yet heard motion to sever. And Mr. Pryor, is there any reason why we can't get that on the calendar as well?
We can, Judge, but before we do that, in fact, my My preliminary motions as they affect the motion for sever have already been drafted. I had anticipated filing them, but they were going to be filed before this hearing, so the court knew where we were. But I received a response to my motion that's coming up from Mr. Wood's office the other day, just yesterday, Tuesday. And I had to take an opportunity to review that and do the research on his last minute response to my motion. So as far as the motion to sever, Judge, and I'm not submitting argument counsel, any of the counsel, but under Rule 14, before the motion to sever is heard, there is a requirement that the court can impose on the state to provide me statements that they intend to use in regards to Ms. Vallow and Mr. Daybell, and to give me those statements. And it's addressed on the latter part of Rule 14. I was going to file a motion asking the court as to whether or not you're going to require the state to turn that information over to me prior to hearing the motion to sever. And if the court wants a formal hearing on that, we'd have to set that first and then the motion to sever. And then, Judge, that's the way I'm reading the rule. But I would expect the motion to sever can be heard probably within 30 to 45 days if that's acceptable to the court.
All right. In lieu of setting the hearing on that today, counsel, just be aware that I do want to get that on the calendar under Rule 14. If you think a preliminary motion is required, Mr. Pryor, file that motion. We can get that heard on a shorter time frame, and then we can look at getting the actual motion to sever calendared, and I'll bring that up with counsel at a later date. I would like to hear that sooner than later, as again, that's going to impact potentially the trial in this case. So,
Judge, if the court wants to set a time for my preliminary motion on the severance per Rule 14 that talks about the statements that both co-defendants would be used by the state against each of them, and the requirement, and it's not, and excuse me, Judge, it's up to the court to decide whether they're going to require the state to provide me those. That's what my preliminary motion would be, and I can have that ready at any time if it's a concern that we need to get the severance issue heard. So if the court wants to set that motion today, I would gladly entertain that and make sure that by either day's end or by tomorrow, I have my request for that information done promptly to this court. So I'll entertain if the court wants to set a hearing on that right now.
all right. At this point, I'm going to interject for a moment. I think we're getting some feedback. I think it's probably coming from Mr. Means, who's not on mute. Mr. Means, thank you. Counsel, in terms of a potential hearing date coming up on a motion, we could have either December 22nd or 29th available.
Your Honor, we'd like to see that motion before we agree to a time that we,
Okay.
if we need to respond to it.
Well, they are going to see it, Judge. Today's the 3rd, or excuse me, today's.
Well, I don't have it yet, Mr. Pryor.
You're
Yeah,
right.
Mr.
You'll
Pryor,
get it.
if it hasn't been filed yet, I'm not going to set it for hearing.
Right.
Just pencil on, if you want to get a hearing set, I've got the 22nd and 29th. Get the motion filed, and then we'll look at an appropriate time for a setting once it's
Okay.
filed. But I agree with the state. If it hasn't been filed yet, we don't need to set it for hearing.
Okay.
All right. I think that will conclude then the issues relating to the scheduling of the trial in this case. We've next got a motion, and I understand counsel would like a sidebar with the court, which will be conducted in the form of what's called a breakout room, where we'll be off. Well, we won't be off the record because I'll have the court reporter record what is stated in the breakout room, but we will not be broadcasting that to the public on the YouTube stream. So, Madam Clerk, if you could please set up a breakout room for all counsel. Then once you see that invite, we'll do that, confirm that it's not being live streamed, and then we will discuss the preliminary issues to that.